Welcome to Tales from the Training Room, Birketts' bite-sized podcast series from the Shaping Excellence team. In this episode, Sam Greenhalgh and Johnny Shevlane discuss the line between workplace banter and what can be considered discrimination. Both Sam and Johnny are members of the Shaping Excellence team, our training department. Sam, as partner, leads the team, and Johnny is our dedicated employment law trainer. They begin by looking at the comments heard frequently in the training room when professionals are being educated on this topic.
So one of the other reasons why we're wanting to focus about this today is we are looking at a society which is changing dramatically in the last few years, and it's certainly something which we've seen in the training rooms. It's been mentioned a lot to us, I think, when we've been delivering ED&I training in the last 6 months, 12 months. One of the perceptions is that we are living in a society which is offended a little bit more easily than it was offended perhaps in the past. Have you heard that? Have you seen that, Sam?
I certainly have questions from delegates in training that says, oh, well, I just can't say anything anymore, can I? Or, oh, I can't talk to you in the break because, you're going to take offence. And there's an element of that that's a little bit sort of jokey and funny and that. But in terms of have I seen that develop more, I think the important thing is that the law hasn't changed significantly for 50 odd years when some of this legislation started to come into force, and certainly it hasn't changed really since 2010 when the Equality Act came in, which governs this area of law. But what has changed is society has moved on and it has developed, and in some cases it's moved on really quite fast, and employers and other people are playing a bit of catch up. So I think what happens is that the media, because we absorb media differently now, it's in very bite-sized, immediate headliner, 2 or 3 lines, and that's it. You apparently know the story. We can have more diverse views on a particular situation or case that we perhaps didn't have 10 years ago.
I think that's absolutely right in terms of the impact of social media, for example, and more bite-sized media chunks, and the fact that traditional media is trying to maybe catch up with where social media is. Coming back to the law, you mentioned the Equality Act, and you mentioned the fact that the law hasn't changed dramatically since 2010. Who can bring a claim for harassment? Who's actually able to bring a claim for harassment?
Usually you think about it as being anyone who's employed, but actually it's somebody who works within a workplace that isn't necessarily an employee, so someone who's an agency worker perhaps, or holds a position of office, like a director or a secretary. You can also have people who are applicants for employment, or even ex-employees who can bring a claim. So that the ambit for who can bring a claim of discrimination is quite wide.
Yeah, and much wider than for unfair dismissal.
Yeah, absolutely. But what is really critical, I think, is that when you think of harassment, you've got to think of 2 separate cases of harassment. The first harassment is where somebody may label behaviour as being harassing, so they may feel that's harassing. So you might feel harassed because the lift didn't work or whatever, or you might feel harassed because somebody didn't make you a cup of tea, and you've got to go and make it yourself, and you've got to battle the kitchen gauntlet, and there's no tea bags and there's no milk, and etc. etc. Alternatively, you might be harassed because of a protected characteristic. And if you've been harassed because of a protected characteristic, you would have a claim of, or you could potentially have a claim of discrimination. So, Johnny, if I don't make you a cup of tea because of your age or because of your sexual orientation, then that could well be an act of harassment under the Equality Act.
Just moving on to that question about who those protected characteristics you kind of highlighted for us. The ones which are applicable in relation to harassment are race, which is broken down into ethnicity, colour, and also nationality, religion or belief, sex, sexual orientation, gender reassignment. Sam, I'm now struggling.
Yeah,
Have you got
disability.
anything? Disability. Thank you very much, Sam.
Yeah.
And then there's a couple which do not count in relation to harassment, which do count in other areas, which are pregnancy and maternity and marriage and civil partnership. But they are covered in different ways. So what about the question about intention? Was it intentional? Could you be said to have harassed somebody unintentionally? That's something which is certainly a preoccupation for a lot of people we train.
Yes, is the short answer to that. So within the definition of harassment, and this is the second case of harassment that I explained earlier, where it is because of a protected characteristic, the behaviour or the conduct that is complained about has to have the purpose or effect. And I emphasise those words because that's the wording in the law, but the purpose or effect of creating a horrible environment for that individual. So if I set out on a course of harassing you, Johnny, by not making you cups of tea, by making all sorts of comments about your age and being generally horrible to you in the workplace, varying different levels of severity, then that would clearly have the purpose. I would set out to have the purpose to create a horrible working environment for you. However, in many cases, in fact the majority of cases, people don't tend to set out on that campaign, and but nevertheless their actions still has the effect of creating that horrible workplace environment, because of course people, creating a horrible workplace environment is quite subjective in itself. So you can have an individual who says, well, that has created that horrible environment for me, despite the fact that you didn't mean it, doesn't matter.
Yeah, so I think this is something which is quite difficult sometimes for the people we train to get their heads around. How could I possibly have unintentionally harassed somebody else? And one of the examples which I often give is in relation to the absolute classic situation, which was probably in garages up and down the country in the 90s, maybe early 2000s, of the page-free calendar being put up within the garage environment. If a female employee came into that kind of environment where there were page-free calendars up around the office or up around their desk, regardless of whether or not and I'm going to make an assumption here, the man who put that calendar up or the woman who put the calendar up, meant for that to cause that person to feel intimidated, you can see how that would make it an intimidating environment for women potentially, because they are having to see objectification of women around them in the place where they're trying to work. And my assumption there would be that a tribunal would be very likely to say that was harassing conduct, even though the person might argue that they had no intention to cause that harassment.
Yeah. And what you've touched on there is the distinction between the subjective element, I find that harassing and offensive, and the objective element in which you would say, well, yeah, you can clearly see why somebody would be offended by that course of conduct or that behaviour. And when we talk about the purpose or effect, if the individual says, well, I did feel offended by that, it did give me that in that impact, that effect, the tribunal will then consider whether it was reasonable for that person to be offended. So when you've got a hypersensitive individual or someone who's assessed as being or accused of being hypersensitive, then the law redresses that balance. And looks at it in that wider context. And sometimes that isn't necessarily picked up by reports, social media reports or more the traditional reporting of cases. And therefore that feeds this idea, going back to your original point, has it all gone too far? Have we all become a bit woke, etc.? Which is not a fair representation of the of the case or the law.
So I was going to ask the question that's probably influenced by those kind of reports. I was going to ask the question, what if someone is hypersensitive? What if somebody is hypersensitive and they are claiming that I've harassed them, but it's actually ridiculous because it's the situation that you mentioned earlier, perhaps, where I've foregone giving them a cup of tea, or I've brushed past them accidentally, but they think that I've brushed past them on purpose in a lift, for example. Those kind of situations where an individual has brought a complaint or brings a complaint for fairly, what we might say, spurious reasons, there's a assumption in the training rooms that we've been in that is the norm now. And I think you're quite right that that's because of the fact that media is kind of pointing out these cases where somebody who's hypersensitive has got some sort of award in the tribunal.
Yeah, and also, what can happen is individuals can complain of a long period of behaviour, but they don't raise it until sort of 3, 4, 5, 6 months down the line. And call me cynical, but often that is because of or that issue has been raised because either that it's gone on too much or it's gone too far at that particular point, and they've sought to introduce these past occasions of harassment, or because there's been an alternative dispute or issue that the employee is not particularly happy with, and they are trying to tactically negotiate a change in the workplace. And they either want to leave with a nice juicy payoff, or they want to move line manager reporting, or move desk, or they want to enforce some kind of term, particularly maybe to work from home more. And so events and situations that occurred in the past are then being used and relabeled as harassment, and that's when individuals are criticised as being highly sensitive or overly sensitive, and the law attempts to redress that.
Yeah, absolutely. And I think this is one thing that I always try to hammer home when we are delivering our training. It's that when it gets to the tribunal, if it gets to the tribunal, the court isn't looking at a comment in isolation. It is looking at it in the context of everything that's gone on. Yeah. And in your situation that you've mentioned, with the several instances in the past which are suddenly reframed at a later stage, the tribunal will have the evidence that it has been reframed, and at the time the person didn't take offence, and that will be evidence that perhaps it wasn't unwanted conduct, as we've mentioned earlier on. So I think that is one of the things which is one of the key takeaways in this area. We are not looking at comments in isolation. Yeah. We are looking at comments in the context that they are said, in the context of what has happened between that person and the individual who is alleged to have harassed them over the course of their time working together.
Yeah. And that fine line of what is acceptable and what is not acceptable to say in the workplace, many delegates come along, don't they, and they go, well, what can I say and what can't I say? And it is that point. It's about the context. We play a game called Banter Bingo, and one of the quotes that go up on the screen that delegates have to answer whether it is harassment or it isn't harassment is, "Oh, you're such a yummy mummy." Now, without any context, most delegates at that point go, yeah, well, that must be harassment, because that's clearly based on unwanted conduct, based on sex, which had the purpose or effect of creating a horrible environment for the person, for that individual. Actually, that comes from a case in which the employee comes back after a period of maternity leave, has a mug that says "Yummy Mummy" and a picture of her and her daughter on this mug, has a little wooden sign from a craft fair. I never know what the point of those things are, but anyway, she brings this little wooden sign in, hangs it on her little notice board in an open plan office that says "Yummy Mummy" on it. A male colleague makes her a cup of tea, puts the mug down on the desk and says, "Here you go, you're such a yummy mummy." And she complains of harassment, and the tribunal corrected that position, if you like, and found that actually no, that wasn't harassment. She had labelled herself a yummy mummy by the items that she had brought in of her personal effects, and she couldn't then rely on the protections of the Equality Act. to pursue her claim in that context.
Yeah, just to say, I think 999 times out of 1,000, that kind of comment will be harassment. But this was the 1 in 1,000 time when it wasn't, and for the reasons you mentioned in relation to the context that comment was made within. But I think that's the key from today. I think the thing which we really want to hammer it home is the fact that it is going to be down to context. The tribunal is allowed to look at everything that's happened between the two people, and sometimes a tribunal will come to the conclusion that what has now been perceived to be unwanted conduct was actually something which wasn't unwanted conduct at the time, given the relationship between the two individuals.
Yeah.
And it's stuff which we know instinctively, I think, quite often. You can push the boundaries perhaps with somebody who you have a closer relationship with at work, but just because you can say one thing to somebody, it doesn't mean that somebody else won't necessarily take offence. We know this from childhood. We know this from the school playground, to be honest. Yeah. It's not learning anything new. It's applying that and applying the ideas of tolerance and applying the ideas of civility, being civil towards each other in the workplace. Yeah. That's not going to lead you too far wrong, I don't think, in many cases.
You would hope not.
You certainly would hope not. So thank you very much today, Sam. That was really great. It hopefully gave a bit of an insight into what we do and one of the key subjects which we've looked at recently. Big takeaway for everybody, context is key when we're talking about harassment.
That was Sam Greenhalgh and Johnny Shevlane discussing banter in the workplace. If you found this episode of Tales from the Training Room useful, our Shaping Excellence team has a whole host of employment training courses available. Our training is practical, insightful, and always provided by the best legal professionals. Head to our Shaping Excellence training page at birketts.co.uk to find out more. This podcast has been produced by Birketts. The content of this podcast is for general information only. It is not and should not be taken as legal advice. If you require any further information in relation to this podcast, please contact us in the first instance via our website, birketts.co.uk.